My dear friends, in recently concluded parliament session, the central government led by Modi and Amit Shah introduced the Constitution 130th Amendment Bill 2025, and there is a huge controversy over it. So in that context, I would like to share my views with all of you how this amendment bill is dangerous to the democracy. The Constitution 130th Amendment Bill 2025 and the BJP washing machine, a tool to silence opposition. My friends, in Indian politics over the last decade, a disturbing pattern has emerged. Leaders of the opposition parties are relentlessly targeted by the central agencies such as the CBI, ED, IT, and yet once these same leaders, if they switch sides and join the ruling Bharatiya Janata Party, the cases against them suddenly disappear or lose momentum. The phenomenon has earned a popular label that the BJP washing machine, where the tainted leaders enter with corruption charges but emerge spotless after aligning with the ruling party. The BJP washing machine in action. Several high-profile examples illustrate how this political cleansing works. Number one, Ajit Pawar, accused in irrigation and cooperative bank scams, saw investigations stall once he joined the BJP-led NDA in Maharashtra. Praful Patel, once probed for the Air India Indian Airlines scam, received reprieve after aligning with the BJP. Number three, Himant Biswas Sharma, under Sharada scam investigations as a Congress leader, emerged unscathed post-defection to BJP and now serves as Assam Chief Minister. Fourth, Suvendu Adhikari and Mukul Rai, both named in the Narada and Sharada scams in West Bengal. But after joining BJP, central probes effectively slowed or stopped. Narayan Rane, probes during his Shiva Sena days vanished after his switch to the BJP. He later became Union Minister. Then Ashok Chavan, accused in Adarsha housing scam, found reprieve after leaving Congress and moving towards BJP. Then number 7, Naveen Jindal, facing coal scam allegations but no progress after political alignment with the BJP. Reports suggest that since 2014, 23 of 25 opposition leaders who faced corruption probes and later joined BJP received relief from investigations. This selective targeting has entrenched public perception that investigating agencies are being misused for political ends. The growing abuse of draconian laws like EAPA and PMLA to target political and ideological opponents and dissenters is already a disturbing trend of misuse of legal frameworks. The 130th Constitutional Amendment Bill 2025, amidst this backdrop of all this situation, the Union government introduced this bill, and the bill mandates that if a Prime Minister, Chief Minister or a Minister is detained for 30 consecutive days on serious criminal charges, for which the punishment is up to 5 years imprisonment, they will automatically cease to hold office. Crucially, this does not require a conviction. A mere detention is sufficient. Opposition leaders, jurists, legal experts, and civil society have widely criticized the bill, expressing the fear that the bill opens a new way for the concentration of power with the center, which is legitimate. Though it is mentioned that it equally applies to the Prime Minister, it is a known fact that all the investigating agencies are under the control of the center. The possibility is almost ruled out, as no central agency will ever arrest or detain a Prime Minister. On the other hand, we have seen that already several opposition chief ministers and other leaders were arrested. As such, this enactment is seen as a weapon to be used against political rivals. Under the new law, an elected leader can be removed from office by mere police action without trial or conviction, which goes against the well-established legal position that a person is deemed to be innocent until proven guilty. Thus, it undermines the federalism by allowing central agencies to destabilize the state governments through politically motivated arrests. Number two, violates due process since removal from the office is triggered by detention, not conviction. Then erodes democratic safeguards, ignoring the principle of innocent until proven guilty. 4. Enables authoritarian misuse by handing the executive agencies the power to topple the governments through legal maneuvers. Then that's why Rahul Gandhi described it as a medieval regression. Rahul Gandhi, the leader of the opposition in the Lok Sabha, lambasted the bill as regressive, likening modern India to a feudal state. We are going back to medieval times when the king could just remove anybody at will. If he does not like your face, so he tells ED to put a case, and a democratically elected person is wiped out within 30 days. And the same is reported in the Times of India. And Kerala CM Pinarayi Vijayan called it a neo-fascist strategy. And neo-fascist strategy which is engaged, and it is also a diversion tactics, my friends. Then such as the constitutional experts such as Indira Jaising and Sanjay Hegde have warned that the amendment effectively weaponizes the constitution against political rivals, while Mamata Banerjee termed it as a super emergency. So it is also a diversion tactic, my friends. The timing of the bringing the bill is when whole country is engaged in the intense debate about the blatant partisan role of selected commissioners of Election Commission of India, and Rahul Gandhi and other opposition India bloc leaders' vote chori campaign, which is in full swing. The Modi government came up with this constitution amendment bill desperately to divert the attention of the people, of which tactics it is well versed. And it is a tool for silencing dissent. Seen together, the BJP washing machine phenomenon and the 130th amendment bill appear as two sides of the same coin. The first reveals how opposition leaders are coerced into joining the ruling party through selective harassment and reprieve. The second creates a structural tool to institutionalize the removal of dissenting leaders without waiting for conviction. In other words, those who resist may face detention and automatic loss of office, while those who surrender and switch sides to BJP get immunity. The one-sided equation threatens the very foundations of Indian federal democracy, reducing the investigating agencies and even the constitutional amendments into instruments of political control and suppression. So, conclude, Indian Constitution is built on principles of federalism, democratic accountability, and the rule of law. If the laws are shaped not to strengthen these values, but to suppress the dissent, coerce opposition, and centralize power, then the nation risks sliding into authoritarianism. The debate around the 130th amendment is not just about a legal procedure. It is about whether India's democracy will protect the diversity of voices or allow a ruling party to weaponize the institutions to silence them. So it is the time for all Indians to think of such laws and resist them through the elected representatives, and see that such laws are not passed and came into effect. Jai Bhim, Jai Bharat, Jai Constitution.